Hello to our viewers. We're excited for you to be joining us today. My name is Similo Silwana. I'm the Principal Legal Practitioner at the Legal Aid SA Office, Johannesburg local office, and I'm with my colleague Nthabiseng Pholoana, who will introduce herself. Thank you.
Hello viewers, my name is Nthabiseng Pholoana. I'm a civil legal practitioner for Legal Aid South Africa based at the Johannesburg local office. Today we'll be discussing wills and the administration of estates. It is National Wills Week from 13 until 17 September this week. We'll be providing you with important information on this critical topic and answering your questions.
In the event that you have questions, those are welcome. You can leave questions or give comments about wills and deceased estates. If time doesn't allow us to respond to all of those, look out for a message from us where we will try and answer as many questions, and all of them, in fact, at a later stage.
And if you require legal advice, you can call our toll-free advice line on 0800 110 110. If you cannot call, you can send us a please call me on 079 835 7179, and we will call you right back. Like and share this video to spread the word on wills.
All right, thank you. Maybe to start, we are participating in the Wills Week organized by the Law Society of South Africa. In our country, every province has a body that regulates the affairs of legal practitioners. In our case, here in Gauteng, we have the Legal Practice Council's branch office, which is in Pretoria town itself. So we are one of the legal firms that is participating in the Wills Week, which happens every year around September. So during this session, we assist members of the public who come in and request advice, and we also assist them with drafting of standard wills on a free of charge basis, and we then give those wills back to them so that they can keep in a safe place for them to be used at a later stage. Maybe if I can start, the reason we as a legal profession encourage people to have wills is so that it can regulate and deal with their affairs once they are no longer alive. There are many benefits of having a will, and these are very helpful to members of the public, which is why we are then sharing. For instance, if you have a will, you at least decide for your beneficiaries as to what should happen to your estate, and other people would also put in their wills how their funeral has to be conducted, where they want to be buried. So in short, wills assist in reducing the number of disputes between families, and it can also assist beneficiaries to trace and find assets of the deceased, so that when the estate is being administered, it can then assist to say the testator left these items in his will, then we can then trace them and divide them according to his wishes, which would be on a will. I don't know if you want to come in or should I proceed. There are a few requirements of a will to be valid and for a will to be accepted by the master. Remember, my colleague Nthabiseng is going to be discussing the administration of deceased estate. But when a will is then presented to the master after the master has been notified of a death of a person, the master will look at the will to see if the wills comply. The will complies with the Wills Act. We have a Wills Act, which is a piece of legislation, very short, but the requirements are very important. One of the main requirements is that the person who writes a will is called the testator. The person must at least be 16 years of age, and the testator must have this will done in writing. And one of the first requirements is that that will must be signed by the testator himself. And by signature, we don't only restrict it to signature. The testator might make a mark, maybe say an X or even a thumbprint. But over and above that, the testator needs to have two witnesses, at least two witnesses, who would witness that he indeed is the one, true identity, he's the one who's making the will, and those witnesses would then also sign as witnesses on the will. For those instances where the will is more than one page, each page would have to be witnessed by the testator. Each page must be witnessed by the witnesses, and the testator himself must sign each page. And where the master of the High Court is of the opinion that the will does not meet the requirements of the Wills Act, they will reject it. But that's not the end of the road. The will can still be placed before a High Court, and an application can be made for an order directing the master to accept the will as valid. It happens from time to time that when the testator makes a will, one of the requirements is not met, but that's not the end of the road. As I say, the court can still order the master to accept the will so that the wishes of the deceased can be implemented. Yeah, thank you for now.
So I'll be speaking on administration of estates. What is administration of estates? Administration of estates refers to a process of winding up the estate of a late person. In other words, it involves a process whereby we collect and then we pay the debts and we distribute the assets of a deceased person. It is mainly regulated by the Administration of Estates Act 66 of 1965, as well as the Interstate Succession Act 81 of 1987. Now, this process of winding up the estate can be accelerated if, as my colleague has pointed out, you draw up a will. Because when you draw up a will, you are able to say what your intentions are regarding the assets that need to be wound up. And you also get to have the final say, which is what we call freedom of testation, to decide who gets what and why. Why wouldn't you want to have your final say? So what happens once a person is deceased? Within 14 days, according to the Administration of Estates Act, within 14 days of death of the person, you have to report the estate to your nearest master's office. How do you decide which master's office to go to? Basically, there's about 15 master's offices around South Africa. Within those offices, then there's also 290 service points at every magistrate court. So what happens is once a person is deceased and you kind of figured out how much is the value of the assets of that estate. If the value of the assets of the person who's deceased is less than 125,000 rand, then you can approach any of the 290 service points in your nearest magistrate court where the deceased person resided 12 months before he died. But if the value of the estate of the person who's now deceased is above 125,000 rand, then you have to go to one of the 15 master's offices in South Africa. For instance, in Gauteng, we have two. We have one in Johannesburg, which is at 66 Marshall Street, and we have one in Pretoria, which is at corner Nthabiseng and Francis Board Street. So now we know where to go. We have lost a family member because unfortunately we're living in a pandemic where death has become so inevitable, which is why Wills Week is so important, which is why you are encouraged to please take control of your assets and draft a will. So now we've been to the master's office. What do we need to report an estate? Who can go there? So the people that can go report an estate in the absence of a will, because in a will, the deceased would have said who they would like to be the executor of the estate, being the person who will be responsible for this collection and distribution of the assets. So the people that can go there are the next of kin of the deceased. In other words, this can be the mother of the deceased, the father of the deceased, the mother of the children of the deceased, etc. Which is why, again, it's important to have a will, because when you have a will, this process can be quite quick. Because the other problem that happens is when a person dies and they do not have a will, the family members can't even decide who must approach the master's office or who must approach these different service points at magistrate courts to even just report the estate. Which is why, again, it's important to please draft a will so that you accelerate this administration or winding up process. What do you need to get to the master's office? You need the death certificate of the deceased, which will have been issued by Home Affairs, which is why when we went even on level 5 lockdown, Home Affairs was kept open in the master's office because they perform such a vital function in the administration of estates when someone has died. You need the ID copy of the deceased. You also need the birth certificates and or IDs of all the beneficiaries of the deceased. Whether you like them or you get along with them, they need to be part of that list, because when you get to the master's office or your master's service points, they will then give you a couple of forms to complete. You will be assisted to complete the forms. Do not fear. There are estate controllers at the master's office who come and aid you and show you what you need to fill in, as well as the documents that you need. So what happens when now I'm at the master's office, but I don't know what the deceased person I'm reporting had? Then what you do, the master's office has a general letter that is to different banks and different institutions. So if you're uncertain whether, let's say, your late mother had an account at ABSA or FNB, you just simply go to the master's office. They give you that inquiry letter, which has every bank literally on the letter, and you just present it to the bank, and the bank will give you proof in the form of a bank statement to show the assets. If the deceased had any assets in that bank, then you will take it back to the master's office. So now we know what assets and a list of liabilities that the deceased had, because an estate consists of both. It's not just the good things, but also the bad things. So now we know, okay, we give the master the proof of the assets, then the master will issue either a letter of authority or a letter of executorship. The difference is this: a letter of authority is issued in terms of Section 18.3 of the Administration of Estates Act, and in terms of a letter of authority, it's basically a simple and straightforward estate where the total assets of the deceased are below the amount of 250,000 rand. And the person who's then nominated to be the executor, if it's in terms of the will, it will be the person that the deceased has nominated in his will. But if there is no will, then the beneficiaries of the deceased will have a meeting with the master where they must then nominate either one person or two of them, sometimes three of them if there is no trust amongst beneficiaries, which is why, again, it's important to draft a will to eliminate all of these unnecessary disputes. Because when there is a known nominated executor in your will, then we don't need to go through this process of back and forth on who gets to be on the letter of authority, because the will would have already expressed that and we will follow that. So in a letter of authority, it's a simple estate, it's basic, it's straightforward. A letter of authority can be issued immediately at the master's office, but the turnaround time for you to receive this document that authorizes the authorized person to take control of the assets of the deceased can take up to 15 working days. And now that we are in a pandemic, time periods can change, so please be patient when you're applying for one, as you will receive it. Now, then there's also, so that's when the estate is below 250,000 rand. Now, we then get estates that are above 250,000 rand. And in that case, the master will issue a letter of executorship in terms of section 13 and 14 of the Administration of Estates Act. Now, that is a slightly complicated estate, as it involves quite a few processes that need to be followed. So as much as the master can issue it in the name of a layperson, unfortunately, being a layperson means that you are not familiar with the law, as you are not a qualified attorney, nor have you spent time in the legal profession. In that case, you will have to appoint an agent who will come in and aid you in the administration of the estate, because you have to do certain things like a section 29 advert. Remember, in the letter of authority we said you just provide a list of creditors that you know. If you don't know them, it's not your fault. But now, because we're dealing with estates above 250,000 rand, there is a bit of a burden and more requirements placed on the executor, being the person that the master appoints to take control of the estate. That would be the notice to creditors, as well as the section 35 advertisement saying that the estate is now ready and the L&D has been approved by the master. If you have any objections, please make them known to the executor at the master's office. When dealing with a letter of executorship, the master gives the person appointed to wind up the estate a period of 6 months to complete the administration process. However, again, given the pandemic as well as other challenges that the executor, being the person appointed, may face in winding up this type of estate, you can apply to the master for an extension stating the reasons why you cannot complete the administration of the estate. We do find from time to time that some clients complain that this estate is taking too long. Why is it 5 years and I still haven't received anything? When, like I said, when dealing with letters of executorship, there's always pressures or things that happen beyond the control of the executor. But when you feel that the executor is the reason why the estate is not moving forward, you can lodge a complaint against the executor at the master's office, because the primary function of the master's office in the administration process of an estate is to supervise the orderly administration of the estate of the deceased. Now, as my colleague has pointed out, what happens when you're not happy with the decision made by the master? For instance, when challenging a will, you can only challenge the decision of the master in the High Court. For instance, if you are not happy with the fact that in the will of the deceased, you have been disinherited, the master cannot deal with that. You have to approach the High Court. If, for instance, again, you feel that the deceased has left quite a huge portion of the estate to a charity organization and not you, again, the master cannot entertain that, because the master performs a supervisory function, a supervisory administrative function in the administration of estates, which is why, again, when somebody comes and says to the master, I am the spouse, I am the wife, I am this, I am that, the master will direct you to take it to the High Court, which is why, again, please draft a will, and when you draft one, use an attorney, because we know what requirements are needed. As when the master looks at a will, the master looks at the will in face value. They look at section 2 of the Wills Act to see, does it comply? How old was the deceased when he did this will? Were there witnesses? Was it signed? Those are the things that the master looks at. The master is not concerned about this one inherited 30% and that one 40% and this one. No, you take that application to the High Court. So now, let's say there was a will that was drafted and for the deceased person. Now what happens when the High Court application says this will is invalid because it doesn't comply, we agree with the applicant? What then what happens is it means that now the estate will be treated as if the person died without a will. When a person dies without a will, now the law decides who gets what and why. And that law, we call it the Law of Interstate Succession, which is governed by the Interstate Succession Act 81 of 1987. So basically with the Interstate Succession Act, what happens is it gives us a hierarchy of who gets what and why. Remember, we said exercise your will, make a will, have freedom of testation, tell us what you want to happen when you are deceased. So now, because you felt that your assets were not big enough, which by the way is not true. If you own an asset, you can have a will. Wills are not for rich people only. You own a car, you own a house, you own even a cell phone. Please draft a will. It's Wills Week will do it for you for free. So now a person, the will has been declared invalid, or a person dies without a will, then the Law of Interstate Succession will apply, which basically says that when a person dies without a will, we look at one, was that person married at the time of their death? And if so, was that person married in community of property or out of community of property? Again, with the issue of marriage, I just want to remind you guys of something very important. We are living in a pandemic. Death is inevitable. I'm not saying you're going to die, but we are living in a pandemic. So now what happens when, let's say when the pandemic started last year, I was in the process of a divorce, and then and I had a valid will. I gave it to my attorney, or I gave it to my trusted friend who's not a beneficiary in the will, and now something happens to me. My divorce is finalized, but within 2 months of that divorce being finalized, I die without changing my will. The Wills Act is very specific. It says that if you die within 3 months of the divorce, then it will be treated as if the ex-spouse died before you. In other words, they get nothing. But if you die 3 months after your divorce, your ex-spouse will inherit as per your will. Because in other words, 3 months is more than enough for you to put your affairs in order. So in other words, please make sure that you amend your will as soon as any significance happens in your life, be it a divorce, be it having children, be it you acquire more property, etc. Because you do not want interstate succession to decide what happens to your things. So now we see that the person was not married, then the next people to inherit will be the blood children or the formally adopted children of the deceased. In other words, you know your uncle's child that you are helping to raise, but you neglect to go to the children's court and apply for adoption. They get nothing from your estate. That's how lethal interstate succession is. So only the estate will be divided amongst your blood children. In other words, you can have kids that are 3 years old versus kids that are 26 years old. The Interstate Succession Act is written in such a way that it says all the interstate heirs of the deceased must be treated equally and benefit equally, which is why, again, in a will, you can decide who gets what and in what percentage to cater for those young heirs in case something happens to you. So now you die, you are not married, you have no children. Then the next people to inherit are the biological parents of the deceased. Now this is where, when you are a master's representative or a fellow legal practitioner at Legal Aid who does estates, doesn't make you very popular. Because what happens is you cannot, in terms of the Interstate Succession Act, distribute the assets of the deceased to the mother of the deceased when the deceased was married in community of property or when the deceased had children. You cannot skip. You cannot be like, yeah, I'm so sorry for your loss, let me give you a share of the estate. Remember, this is interstate succession. The law has no emotions. So unfortunately, the mother of the deceased or the father of the deceased will only inherit if there's no spouse, no children, then the parents will inherit. But even with the parents inheriting, the Interstate Succession Act says that we give 50% of the estate to the mother, side of the deceased, as well as the 50% to the father's side of the deceased. So in other words, the mother of the deceased will get 50% of all assets and the father will get the 50%. This is to cater in circumstances whereby only one of the biological parents of the deceased is alive. Then what happens is that 50% of the parent who is now deceased will go to the siblings of the deceased from that deceased parent's side. Now, if we have an estate where there is no marriage, no children, no biological parents, then the next people to inherit will be the siblings of the deceased, the aunts and the uncles, etc. So basically, with interstate succession, there is a hierarchy that we follow. It doesn't tie any emotions to it, which is why please do a will. And please also don't forget, in terms of our Legal Aid website, we have downloaded a template of a basic will that you can feel free to go print out, fill it in, and then you can approach one of our officers for assistance to check that the will complies with the formalities so that the master can approve it.
Right. Whilst at it, there is a maybe I could call it a misnomer that for a will to be valid or for a will to be recognized, it has to be kept by an institution or it has to be kept by lawyers. As my colleague has said, once a will has been drafted and properly signed and witnessed, it can be kept at a safe place. There's no specific requirement of what a safe place is. All that is required is, in the event you pass on, people who are going to be reporting your estate would need to know where to find your will.
Yes.
And another thing that I think is noteworthy is that, like my colleague has also said, in the event you change your mind or circumstances change, nothing stops you from going to execute a new will. By the way, a will that is executed today revokes previous wills that are sitting elsewhere. So if you have a will sitting with a firm of attorneys or a bank somewhere, and you then do another will, that will that is sitting with those lawyers is no longer valid, because by you having executed a new will, the old will has been revoked. So it is also important that you keep track of where your will is and how old your will is, so that when it is time for your estate to be administered, we don't face a situation where different family members bring different wills. What the master is going to look at, or the person who's going to be administering your estate is going to be looking at, is the age of the will. The most recent will is the one that is going to be taken into account and used to execute your will. So it is important that when circumstances change, you also go and update the contents of your will, so that at least it caters for situations as they change, and as she says, to also cater for your heirs whose ages might vary. For instance, you might have smaller children who cannot fend for themselves, and you also have older children who would not be as dependent on you as your younger children. Sorry. So it is very important that you keep updating your will as your circumstances change.
Yes.
All right. I think we are at a stage where we can address questions. We had questions that were posed to us, posted on our social media page, and we are going to try and respond to those questions. The first question that we received was from a lady, Bernice Karen, and she says that she and her husband bought a house together, and the title deed is in their name. Unfortunately, her husband passed on, and the house had been paid off, and the title deed has then been given to her. and now she needs to know what she can do or how she can go about having the title deed updated so that it can reflect her name only. Okay, and she also says, unfortunately, she does not have the funds to instruct lawyers to assist her. This is another area of the law where specialist lawyers are involved. They are called conveyancers. In our country, when a property is registered or when somebody acquires immovable property, that registration of that property has to be filed with the registrar of deeds, where some people call it the deeds office. So a title deed, like in Karen's case, would have been registered in her name and the name of her husband. So if there are going to be changes that are going to be made relating to who now is going to be the owner of the property, you would need to use the services of a conveyancer. Not every lawyer is a conveyancer. You write a special exam, you pass it, then you can apply to the court to be admitted as a conveyancer. That then allows you to deal with a transfer of properties. In Karen's case, unfortunately, legal aid does not have conveyancers. It might have conveyancers in its employ, but it is not permitted by the rules of the Legal Practice Council to deal with conveyancing matters. So in your case, you would need to find a conveyancer closer to where you live, who would then give you an estimate of what it would cost to have the property transferred into your name. And what I have seen in the past is that, for instance, where there isn't a lot of transactions that are going to take place, for instance, the registration of a bond and all those things, the costs are going to be minimal. And you might then be in a position to negotiate fees with the conveyancer, and they might also be agreeable to you paying them off over a period of time. So unfortunately, as legal aid, we are not able to assist. We can give you advice, but we cannot draft papers to effect transfer. We cannot file papers at the deeds office. We also cannot appear in front of the deeds office to effect transfer from one person to the other. So yeah, that would be our answer. All right, the next question we have is a bit long, but I'm just going to summarize it. It is from Sisonke Mja, and he says his father passed on in 2020. His father was working for the Defense Force, and fortunately his father had a will which they found in a suitcase, and there was also another will which they found from a lawyer. And he says, fortunately, the two wills are the same, so it would mean one is a copy of the other, which is good because then at least the father tried to have his will kept in different places in the event the lawyer is not traceable for him to produce the will, but at least another copy is found. Sisonke suspects that there might be something untoward with regards to the administration of the estate. The reason he says this is because initially, as a family, they were being updated as to what is happening with the administration of the deceased estate. But as time went on, they suspect that their stepmother is playing hide and seek and is no longer communicating the progress with regards to the matter to them. So the advice that we can give to them is that nothing stops the family or anybody who is an heir in the will to approach the master directly if they don't get assistance from the lawyer who is assisting with the estate. The estate file at the master's office will have an updated content of what has happened thus far. So if the lawyer has filed what my colleague was referring to as the L&D account, which is the liquidation and distribution account. They could also get a copy of that. They could also check on their local media, because the L&D account has to be advertised before the master can, and it must lie in awaiting inspection and for objections to be raised. So all those are things that, even though they don't get cooperation from their stepmother or from the lawyer, they can still access that information independently. And if there are problems with how they feel they are being treated, they can still raise concerns with the master, or they can approach an office of legal aid closest to where they are for them to be assisted to see what is the progress with regards to their matter. Yeah, thank you.
Okay, so I'll do question 3. This is a question from Bafana Dlamini. Why my sisters and my brother's children are included in the interstate succession of their grandmother if their parents have passed away. The fact is, the children inherited their parents' estate without sharing with anybody. And when their grandmother passed away, the same children must inherit their grandmother's estates while they live in with their fathers, and some are married. I don't understand why the interstate succession thing is not changed to benefit the children of the deceased grandmother. Now, this again takes us back to what my point of emphasis during this conversation, which is, if you draft a will, the law doesn't have to come in and dictate to you who gets what and why. Because like I said, the law is not an emotional endeavor. Because I can see here, I understand that, but finally, I mean, when you wrote this, I can hear the emotion, I can feel it, because having been a master's representative for quite a lot of estates here in Johannesburg office, I deal with this type of question all the time, and it's mostly from the mother of the deceased. Do you remember when I was talking earlier, I mentioned a hierarchy, which is basically a formula, as some might call it, of who gets what and why. Now, because the first thing we need to point out is, this grandmother died in terms of interstate succession, not testate succession. Because in testate, the grandmother would have had a will, where in a will, as a parent, you can inherit or disinherit whoever you want. Which is why a parent of 5 can choose to give her house, the ownership of the house, to 3 of her kids, and only give 2 of the children the use of that house. Now, in this specific question, because the grandmother did not have a will, it means that she died interstate, which means the law must enter and decide who gets what and why. Now, in this case, I'm assuming that the late grandmother was not married, but remember we said if a person died without a spouse, the next people that are eligible to inherit from that estate are the biological children of the deceased. In other words, your sister's kids and your sister and your brother are the biological children of the grandmother, who I'm assuming here is the mother of Bafana Dlamini. Now, what we do is in interstate succession, we look at the total number of biological children of the deceased. By what you've written here, I'm making an assumption that it was 3 biological children, of which 2 predeceased or died before the grandmother. Now, what must happen is, in terms of interstate succession, if the 2 children, being the brother and the sister of Bafana, at the time the grandmother died, had children or their own descendants or biological children that had left, which are the children that is referring to in this question, then we have what we call per issue or per sturs in law. What that means is those biological children stand in to inherit for their biological parents, who were the biological children of the grandmother. In other words, just because they died, it doesn't disinherit their parents. So they are basically inheriting in terms of interstate succession per issue, meaning standing in as the children of the sister and the brother. But the one thing that I can tell Bafana Dlamini is, you will not inherit the same amount. So what that means is, let's say the late grandmother's estate had 250,000 rand in it. So what happens is we'll divide the total value of the estate by the total number of biological children of the grandmother, meaning it will be divided amongst Bafana, the predeceased sister, as well as the predeceased brother, meaning we'll divide everything by 3. Then whatever we get, those children will get their deceased parents' share. So in other words, Bafana, you will still get more from this estate, because let's say your late sister had 5 kids, they'll share their mother's share, divide by 5, whereas you get your mother's share on its own, as in that ratio. Again, make a will, this won't happen. But if there is no will, interstate succession comes with a formula, and yes, it will look like they're benefiting all around, but their deceased parents are still children of the grandmother, so they have to benefit per issue, standing in for their deceased parents.
If I may just come in this example that you are dealing with, I've heard stories of, for instance, other grandchildren,
yes,
complaining that why are their cousins benefiting when they also as grandchildren don't benefit from their grandmother. But the explanation is that they are inheriting in the place of their deceased parents.
That's correct.
It's not like the grandmother is saying, I'll benefit these grandchildren, my other grandchildren. The way to have avoided that would have been a will.
Yes.
And by the way, as we say, the person who writes a will, as the family dynamics change, they can also change their will to say how their estate needs to devolve. So unfortunately, that's how the law on interstate succession works.
It has no emotion.
Yes, you might find yourself sitting with a problem that makes you enemies as family members, but it could have been avoided if a will was drafted initially. All right, thanks. Now, the next question that we have comes from a Mr. Ronald Nicholas, who says he's from Worcester in the Western Cape. And he says his children are both dead. There were initially 7 children. There were only 7. Now only 6 are alive. 1 has passed on. And when the father passed on, I assume he was the last one to pass. Oh no, he was the first one to pass on. The youngest wife, the youngest child of the 7, and his wife and his children moved in with their mother. And he says at a later stage they discovered that their sibling made their mother sign some documents which they as children didn't know of. And he doesn't have copies of those documents that were signed. So I assume he's worried as to what was their mother made to sign. And because he doesn't have copies thereof, he doesn't know where he stands with regards to the inheritance and the like. What I can say is, because you have already at least told us that you are in Worcester, we have an office in Worcester as well that you can approach. If I was sitting in that office in Worcester and your concern relates to the law of succession, I would then write to the master's office in the area to inquire as to what is in the estates file, and if the deeds office as well, to check if the title deed for this house is still in the name of the mother, who it appears is still alive. Because if, for instance, something untoward was done, it can still be fixed, especially if the mother is still alive. Rather do it sooner than if the mother is no longer alive, then it becomes a protracted High Court application that would be costly and it would take time to resolve. So my suggestion would be visit our office in Worcester so that they can see how best they can assist you. And by the way, our services are free of charge, provided you qualify. If you don't qualify for legal aid, you can still be given legal advice and referred to other organizations that may possibly assist. Yes.
And then just to add on question 4, the Master's Office also has what they call the Master's Portal. So you just go on your phone or on a PC and you just type in Master's Portal, you click on the link, and then it will take you to the deceased portal of the Master's Office, where you can conduct a deceased search. This is the first point that I do as a Master's representative to check whether an estate has been reported or not. Then you'll be able to see, one, was your late father's estate reported at the Master's Office. You just need to know the ID number of the deceased, or the full name and surname of the deceased, or the estate number, which at this point you wouldn't know because that's what you're looking for. If you type in the ID number of the deceased, it will give you all the details if the estate has been reported. It will tell you at which Master's Office, who's the representative who reported, the family representative or attorney who reported the estate, where it was reported, and whether a letter of authority or a letter of executorship was issued. Then when you have that information, you are able to approach that specific Master's Office and apply for copies of the Master's file in your capacity as a potential beneficiary. You will pay for the copies, but they'll give you better insight on what's happening with the file. If you find that it says no results, it means that probably it's not reported. And then, like I said, depending on the value of the estate, if it's below 125,000 Rand, you can approach any of the magistrate courts near you where there is a service desk, a service point where you can be assisted. But if the value is above 125, you have to go to one of the 15 Master's Office around the country. Then you will get that information. When you come to us armed with information, we are able to assist you better, because we can't just sit in a consultation and be making assumptions or thinking, maybe it's reported, maybe it's not, maybe it's this. But when we have copies, we are in a better position to give you legal advice and to assist you if it's through a court application for a cancellation of a title deed which was fraudulently obtained. We have a High Court unit at Legal Aid that does that litigation for you. But also, you need to also arm yourself with information, and you can get information on whether the estate of a person has been reported or not. Even though when I started talking, I said within 14 days, you can report an estate after 14 days. It doesn't mean that now the 14 days since the person died has expired, you cannot do it. Death is hard, people grieve. People grieve for different periods and different cultures or traditions. So it's okay if you go there after 3 months, but just remember that you need to give us information so we can help you better.
Well, while still on the subject, Nthabiseng, I must also caution our viewers and members of the public that we've seen instances where a client comes to you and they are claiming to have inherited this property from their grandmother. So they are third generation.
Yes.
And when you go back, even they themselves have not reported the estate of their parent. So the longer you take by not reporting, you are making the administration of all these estates difficult, because whereas your grandparents had maybe 4 or 5 children, now if we have to go back until all these estates have been administered and finalized, it might be difficult for you to even lend or deal with your share or your parents' share. So the longer it takes for you to report the death of a family member, the more difficult you are going to make for yourself and the person who's going to be assisting you with the administration. So as Nthabiseng says, if you had to wait for 3 months because of your grieving period, as soon as you get an opportunity, start the process so that, you know,
we don't have to go back 1998.
Yes, because sometimes
to get to 2021.
Sometimes the information that you need is sitting with somebody who's no longer alive, or the documents can no longer be found. So it's going to be sounding unfair when we now say we can't rely on.
You need to report that estate first.
Yes. So, okay, thanks. Can we then go to the fifth question, which is one of the very common questions that we find in our country? This question comes from Ms. Norke, Naomi Norke, who says she has been living with a man for 21 years. Unfortunately, the man passed on now in August. He had a will that he had drafted before they met. And her question is, can she put in a claim? Remember what we said with the freedom of testation? If he had a will and he had that will before they met, chances are, well, it's a foregone conclusion that she would not be in that will, and it would be unfortunate for her, as it is presently, that she lived with this man for 21 years. The man never changed his will. Circumstances changed, and the will that he made in 21 years ago, before they met, is no longer as current and catering for his changed circumstances. So unfortunately, his estate is going to be dealt with in terms of that will that he had drafted. The reason I was saying this is a common thing is that if they were not married, it means she cannot get the benefits of a married spouse, because if she was a married spouse, she would then have been better prepared and protected by the law. But that does not close the doors to her, because she says they owned a business together, and that business owned a house, and she needs to get, that's her question, she needs to get half of the rent that she would need. But she also says, unfortunately, she has no evidence. Sad thing that she has no evidence, and she doesn't know what to do. My advice to her would be to seek legal advice from an office of legal aid closest to where she lives. There is what we call in our law universal partnership. When they consult with her, they would have to check if the principles of universal partnership apply in her case, and if they do apply, then she is going to find that whereas she is not a beneficiary in terms of the will, she is at least going to get some benefit. Remember another thing with the will, which is also a misnomer. When you write a will, you can only give what you own. For instance, if you are a married person, you cannot say, I'm giving all my estate to my children from my previous wife. No, you can only give 50% if you are married in community of property. So even in this case, if they acquired this house together after he had drafted this will, he cannot give this house 100% to the people that are listed as beneficiaries in the will, because he does not own the entire 100% of the house. She has a share, which is why we are saying the principle of universal partnership might come to her benefit, and it might turn out that she is entitled to some substantial benefit which she wouldn't be able to access if she does not pursue it. So best advice, seek legal assistance from legal aid, or if you are able to find other lawyers that you would pay, you can still do that. But first place, go to legal aid. It would cost you, you wouldn't be charged for legal advice, and if you qualify, would still be able to assist you without charging you a cent. Yes.
We have 6 questions that have come in during this live.
Yeah.
The first one, I think it's the same Sisonke as there.
Yeah.
Sisonke is asking, can a will that is signed by witnesses but not the owner of the will, so I assume the person who's now deceased, can that be considered?
Well, That's one of the questions that we did raise earlier. Yes, unfortunately, as we had said, the master is not going to accept that will as valid, but it does not close the door for that will to be. Remember, the master cannot decide on the validity of the will, because if they were to do that, the next thing they are going to be. They're going to be accused of favoritism and whatnot. If the will does not comply with the requirements of the Wills Act, only the High Court can cure the defect. And it happens quite a lot that the High Court would say, well, although this will does not meet the requirements, but is not as fatal as the prejudice would be more if the will is not accepted as opposed to it being accepted. So the court can still give an order that says, master, you will accept the will. The other people who would be prejudiced if the will was not to be accepted, the prejudice exceeds more the benefits. So there is still a chance that the High Court can give an order to the master to accept the will as valid. But it would be on the basis of a court order. Thanks.
Then Simone asks, I just want to know, if you have a will and the person of the property is still alive but is in a home, can you evict people living in that house if they are not paying any rent?
Well, it will only comes into effect upon death. So what that person is looking for is what we call a power of attorney from the owner of the property, authorizing that person to act on their behalf to institute eviction proceedings to evict these people. So there is a difference. It will only comes into effect upon death unless it's a living will. A living will is basically what you would ask your attorney to assist you to draft in case, for instance, you get into a car accident and you're in a coma, where you basically want to direct your attorney to direct the doctor to switch off the machines. That's a living will. But in terms of, this is my property, I'm going to leave it to my daughter, but until I've died, my daughter, that's not her property. So yes, they'll need a power of attorney to do the eviction.
Delirik asks, must a will be drawn up by both parties of an out-of-community of property marriage dating back to 1979? Can either spouse draw up a will against a property that has been acquired jointly?
Okay, so like my colleague has answered, right? Freedom of testation basically means that, in other words, you do not need the consent of your spouse to decide what to do with your property. And if it's out of community of property, it means it's my property. But if we've acquired it together, that just means 50% is yours and 50% is mine. I can do what I please with mine. You find this issue comes up a lot with blended families. So where you have the mother came with 2 kids from a previous relationship and the husband came with 2 kids from a previous relationship, or with 3 or 4 or 5, and the mother wants to protect her 2 kids from the husband's other kids, especially if they are older, then that's when a mother would, in a blended family, would draft a will, but for her 50% share, if this is a joint property or if they are married in community of property, which is why, like my colleague said, you cannot give what is not yours. So even if you write your will and you're like, I give my house to my kids, unfortunately that clause will be invalid because it can't be carried out because you gave away something that's not all yours. They'll only be given 50%, which is your half share.
Gugu asks, can I get a letter of authority for 2 estates houses on my name?
Okay, so by 2 estate houses, I'll make an assumption that this person is referring to 2 different estates. This is another misconception in the administration of estates. People think that because you are married in community of property, if, let's say, both the husband and the wife die in a car accident, they fall under the same estate number. No, you don't. Remember, you have your own ID number. He has his own ID number. So when it comes to reporting estates, what you will do is, the minute you submit the title deed and the marriage certificate to the master's office of, let's say, the husband and the wife who died simultaneously in a car accident, both estates will consist of half shares. In other words, the husband will allocate his estate number, and his letter of authority will reflect the half share of the
50%.
property. Yes, the undivided half share, because we can't split a house. And then the wife will also be allocated her estate number, and her letter of authority will reflect her half share of the property. So yes, each person who's reported gets their own letter of appointment. In community, doesn't go with everyone gets under one letter.
And it's possible that both those can be given to one person.
Yes, like I have a file of a husband and a wife, so the difficulty with those files sometimes is when you can't determine who died first, then you basically want to decide the estate separately. But sometimes when you can, let's say the wife died in May and the husband dies in June and they were married in community of property, then we know that based on the value of the estate, the wife's estate will firstly accrue to the husband's estate, then you divide. Yeah.
Laiba says, how long does it take for the will to be finalized and the beneficiaries contacted?
What? Okay, I'm just unclear on how long the will takes to be finalized. Because basically, remember when we spoke about reporting the estate, a person who reports the estate is someone who has a document which seems like the last will and testament of the deceased or the next of kin of the deceased. Like my colleague pointed out earlier, like in one of the questions here, it is possible for a person to have 5 wills and forget about the other 4. And now the master is faced with will number 1, will number 2, will number 3. The master will take into account at face value again the one with the latest date, because it cancels the other one. That's the first point. Then again, like we said, for the master to make a decision on the will, remember their function is administrative. They look at the will at face value. Okay, has it been signed? How old was the deceased on the day he made this will? Okay, there are 2 witnesses on each page of the will. Does it comply with Section 2 of the Wills Act? Yes, it does. Accepted. If a person is not happy about that, they have to go to the High Court. They don't bring witnesses who were there to the master. The master will just be like, wrong place. High Court application, go make your case there regarding this will that I've accepted or rejected. So once a will is presented to the master as the original will and last testament of the deceased, the master looks at it at face value as it is on that day and makes a decision. If you're not happy, High Court application.
We have another question from Alphios, who seems to be a client, but I think I still want to read it out because I think many people have the same query. Okay. It seems they have spoken with their legal aid, say lawyer, yesterday, but there is a delay in receiving the letter of execution. So the lawyer has said that they've been waiting for the letter since October last year, and yesterday the client was advised that they may only receive the letter next year. So I thought this was a good query to respond to in terms of the delays you mentioned because of the pandemic.
Yeah, so like I explained, with a letter of authority, which is a straightforward estate, you can receive it immediately on the same day at the master's office, provided you have all the documents that they've requested from you, which are available on their website, right? Immediately you get to an estate controller, you give them everything, they type, they give it to an assistant master, boom, you have your letter, done. But now with a letter of executorship, because like I mentioned, it's a slightly complicated estate, and you are a lay person, meaning you have no legal qualification or knowledge, you need an agent, meaning you need to go find yourself an attorney or a trust company or a qualified chartered accountant to assist you with the administration of the estate. In other words, that person will be required in terms of Section 23 of the Administration of Estates Act to provide security to the master that they will help you do the estate. If they don't do it correctly, then they will have to basically provide remuneration or compensation cover to the beneficiaries, which is why a letter of executorship is that complicated, especially when people are like, I don't have enough money and all of those things. But in terms of the turnaround times for specifically a letter of executorship, it's 15 days under normal circumstances. I know it sounds like sometimes attorneys, we keep saying pandemic, but unfortunately it's a reality. It's the same with the banks. When you're starting now to wind up the estate as a master's representative, you find that what used to take 2 months to close, because an executor must instruct the bank to close their account. Now what used to take a month is now taking 3 months or 4 months. And when you go to the bank, where they used to have 10 consultants available to assist you, they now have 1. So at the end of the day, unfortunately, you have to be patient. But like I said, if you feel that this delay is not on the part of the master's office, but of the attorney themselves, the master's office is not a bring your lawyer, or you can't come talk to us. You are a beneficiary, you are an interested party. You can approach them, speak to the master and find out what is happening with my files. But the other thing you need to understand is with the master's office, because they also have physical files, but until about 2014, the files were handwritten, but now they have electronics, and now they can put everything in a computer. But it still doesn't mean that everything goes quickly, because even with them, they have to comply with the COVID-19 regulations, and they have to limit the number of staff that come into the master's office. So basically, you have to be patient and keep calling and keep going there and keep queuing outside. But sometimes you get there, they're like, cut, we're only seeing 30 people today because we have the capacity for 30 people. So that's where a bit of patience comes in, especially in these times that we're in of COVID-19.
2 more questions, but these will be the last 2.
Yeah.
Okay.
From Pumi. My mom has a case against her nephew who did a letter of executorship without her knowledge. Now we have sent emails to the Johannesburg Master's Office, and even the police have tried to get the file from the Master's Office, but it's not available. In this case, what can she do to get help to dispute the letter of executorship?
Okay, so first of all, like I mentioned, guys, files get misplaced. I know that especially when you're dealing with deceased estates, the minute a person goes to the master's office and they're told, we can't find your file right now, they start thinking, there's some shadiness happening here. No, guys. Files do get misplaced, just like you misplace your keys. It does happen, but there are things that you can do to get your file. Like I said, when you need copies of the master's file, you fill in an application form and you pay a certain portion to the justice account where you can retrieve these copies. Then usually they'll tell you 2 weeks, come back and check. You go after 2 weeks, they are not there. You go after 3 weeks, they are not there. You go after 4 weeks, they are not there. Yes, you are running out of patience. But unfortunately, so what they do is they will keep looking for a file, which is why you keep making the application. If at some point they find that they've looked at every storeroom in the master's office, and let's say one of the files that you're looking for was not the files that were already scanned into their new system where they're electronic and stuff like that, they will look into possibly creating a dummy file, meaning a duplicate file to replace the original that is lost. When that happens, you will be called, you will be informed, and you will be requested again. See, in this case, the nephew reported the estate. He will be called again to bring the reporting documents again. So it's as if you are reporting the estate again, but it's a way that they try to solve issues whereby they can't find the file. But it does happen that files get lost. And now with regards to the process of the removal of an executor, like we said, you lodge a complaint, you do it in writing. The master will listen to you, one of the assistant masters. They will take down your complaints. Remember, there are always 2 sides to a story. Doesn't mean you get there like, yeah, we are firing this executor. No, the master will listen to you. They'll put down everything you've said against this possible executor. Then a letter will be sent to the executor by the master via registered post, and you can also be given one to hand deliver yourself, which when family members are not getting along, they take a member of SAPS with them to deliver the letter. Yeah, it's that dramatic sometimes. Then you will deliver the letter to this executor where they are told, come to the master's office for a meeting on this day. There they will have a meeting with all the interested parties where now the master will ask, what is the issue? What is the problem? Then you basically list your grounds why you're saying this person should not be the executor of the estate, be it because they're not doing their job or they fraudulently applied to be appointed and stuff like that. Then the master will physically, in the letter, they also ask the current executor or executrix to bring the original letter of executorship. Then if the master is satisfied that this person was not supposed to be appointed, they will physically cancel out the letters of executorship that were issued to that person, and they'll cancel it on the system as well. Then you'll be given another nomination of who now must be the executor, which must be decided by the heirs.
And by the way, if the executor who is called upon to come to a meeting does not come, and they continue to use a letter of executorship or a letter of authority that has since been withdrawn, if they continue to use it, they are now committing fraud, because the master is no longer, the master has said that letter is no longer valid. So wherever you go to present that letter as a valid document, that would be false, because it has been withdrawn. And by the way, also, if for instance the complaint that is before the master can be resolved by adding another person to be a co-executor, that can still be done, so that at least some family members would feel that if we can't get hold of one
Especially
member,
siblings,
they
they all want to be on it.
Yeah, it is possible that on the letters of executorship, more than one person can be appointed as executor. Yeah.
But now the problem you have with that is wherever you go, that person must be there. Wherever you want to sign, that person must sign. So it's as if you are marrying yourself to that co-executor, because every instruction to the bank, like with legal aid, we deal a lot with banks because of the nature of the estates that we do. Like FNB, for instance, only accepts an instruction to close an account signed by the executor. So if there's 2 of you, 2 must sign. If there's 3 of you, 3 must sign. So it's best to just trust each other or write a will.
Our final question is from Donna. She says, a certain bank is the executor of her mother's estate.
Yes.
After a year of not achieving anything except receiving a standard email which says that the matter has been forwarded, the estate is still not finalized. Her mother died when she was 89. She had no debts and she did have a valid will. How long is this expected to take?
Again, different estates have different time frames, which is why even on a first consultation that I have with a client for the administration of the estate of the loved one, one of the estimates that I give a client is how long I estimate their file will take. In other words, I have no guarantee that in 3 months will be done. Because like I said, before the pandemic, when dealing with institutions like, for instance, I remember Netbank, they used to be very quickly. So basically you would send an instruction and tell them, please close this account. And immediately, within 2 weeks, their account would be closed. Then unfortunately, we went into a pandemic. And now even when you send something to them, you do get an auto response whereby they inform you so that you can inform your clients that, listen, we have a bit of a backlog because of the pandemic and etc., etc. So which is why when you are a master's representative or an executor of an estate, communication with your client is crucial. Even if you feel like you repeat the same thing every week, but you need to keep your client in the loop so that they don't feel like, it's been a year, what is happening? So every time you get that auto response, you inform your client, listen, I've spoken to the institution, I have asked them why is it taking so long, and they've said they have a bit of a backlog. Please be patient. And like I said, if you feel that the reasons the executor or the master's representative is advancing to you are not sound, or they don't make any logical sense to you, you can approach the master's office where you say, it's been a year. This person is not doing anything. May I please fire this person? I want another bank to assess me, or I want this, or I want that. The master will listen to you. Do you get what I mean? So at the end of the day, there is no guarantee that there are estates that within a month they are done. There's some years they are still not done. Because, for instance, you're waiting for a clearance certificate or this or that. Every file has its own merit, which is why communicate your frustration with the attorney. Listen, I'm a single parent. I need money. I need maintenance. Please help me. So that the attorney can send an email to that institution and be like, listen, Section 28, the best interest of the child are paramount. Even in a pandemic, please close their accounts because I need to pay maintenance for this minor beneficiary. So like I said, communication is important during the pandemic with your client. What I would suggest is that this person would speak to the executor first and find out from the executor, why is it so long? I feel that the emails you are sending me are auto emails. Tell me something about my file. I need to know. And the person will answer. If they don't, lodge a complaint at the master's office.
I'm sneaking in one last question. I think it's a common query we receive.
Yeah.
If a person, this is from Sonwabile, if a person dies without a will but was married in community of property, the deceased has 9 biological children, the estate is worth roughly 700,000 rand. Will the surviving spouse get 50% of the 700,000 rand plus 250,000 rand, which is greater than the child's share?
That's correct. So Nabile has answered himself, basically. So in interstate succession, we have what we call, with interstate succession, it means that you don't have a will. So like I said, we have a formula. But when you are a surviving spouse in community of property and there are no other polygamous situations there, you inherit twice. So basically what we mean is, in the estate, literally half of everything goes to the wife. Right? Then the other half of the 700, so it's 700,000 divided in half, we get 350, it's not even part of the estate. Then the remaining 350 is what we are dealing with. That's what people need to understand. So the estate of the husband only has 350,000 rand. Then in that 350,000 rand, we need to give the spouse 250,000 rand, or whichever amount is greater, when we take the remaining 350, divide by the spouse and the how many children? And the 9 children. So we're looking at 350,000 rand divided by 10. Can that give us 250? Nope. So what that means is we take 350 minus 250, we are left with how much? 100,000. Now those children will only share in that residue of 100,000, which means they're each getting about 100,000 divided by 9, 10,000 and something. Yeah.
All right. Still on this question. Remember, you cannot inherit from yourself. So in this case, we can only speak of the inheritance being half of what the husband's share is. So when the husband passes on, the wife collects her share, which she owns by virtue of being married in community of property, which is the half. So as Nthabiseng is saying, the next what remains of the joint estate is
350.
350. So the reason she shares first is because she gets 250 or whatever the child's share is. If the estate was worth more, she would not be getting 250. She would be getting equal to what the children are getting. Say, for instance, what remains to be shared was in the millions. So she's not only going to get 250, she's going to get 250 or whatever the child gets, whichever is greater between the two. So if it was in the millions, she would still get what each child is going to get as her share. So the reason she's getting 250 is because she's the first one to be protected by getting 250 in the event there isn't much to be shared. So there are instances where what remains is 150 or 120. She gets that and they get nothing.
Yes.
Because the first 250 of what needs to be shared goes to her as a surviving spouse. And whatever remains, only that then gets shared with the beneficiaries or the heirs of the. So which is why we are saying it's important to have a will. If he had a will, and he would have said, I'm giving my estate to this person, that person, she would only be entitled to her share and only what the husband would have given in his will. So because he didn't leave a will, as Nthabiseng was saying, law of interstate succession, no emotions.
Yeah.
So it is best that you have a will so that at least you can direct what becomes of your estate, what each child gets, and if you want to also give to your parents, your cousins, you have the liberty to decide who gets what.
Yeah. And again, we come across this type of scenario a lot, again, in blended families, where you find that the father had children but then got married. So now you have the stepmother, as they like to label her, and the total value of the estate left by the father is 500,000. Just to sum up what we've been saying, because they were married in community of property and the total value of the estate is 500,000, the spouse inherits everything to the exclusion of the children.
Even her own children.
Exactly, even her own children. So it's not a, how come my stepmother went to the master's office and got the letter of executorship in her name and she's getting everything? She was married to your dad. So again, we repeat, if you draft a will, as a father, bringing your kids into this blended family situation, you can leave something to your children. But remember, you only give out what is yours, meaning that 50% share of your estate you can give to your kids so that you don't die intestate. And the law says 500,000, wife gets 50%, 250. Next 250 or the child's portion. Now there's zero for your kids. Draft a will. It's Wills Week. We are here to help. Yeah.
Thank you for joining us today. If you have any further questions, you can still continue to send these messages on Facebook, or you can also call us on our toll-free number, which is 0800 110 110. By the way, we operate Mondays to Fridays,
Yes.
Monday to Thursdays between 8 and 4 p.m. and on a Friday it's from 8 until 3 p.m. If you are not able to get through to us, we still have a please call me number, which we receive messages thereon, and then we then respond by calling the clients back to hear what assistance they need, and we can then assist them.
And yes, please remember to like and share this video to spread the word on wills. And also don't forget, you can get hold of us on our advice line for any legal advice or assistance on the drafting of wills or any questions you might have on interstate or testate succession. Our advice line is 0800 110 110. If you're running low on airtime, don't worry, you can send us a please call me on 079 835 7179 and we will call you back.
Thank you.
Thank you.
Thanks.